excited to have them talk to you. I know a lot of you were able to put in your own questions, and they've had a chance to kind of look at those. We're going to do this kind of roundtable style, not formal presentation style, because I just thought it would be good so that y'all could interact and ask your own questions and ask what comes up. So do that. It's from going to close right at 1:30. So thank you guys for lunch, because they also sponsored lunch. So thank you for that. And I will leave it to Robert, Corey, and Mark.
Yeah, we're happy to be here. Corey and I are obviously with Reese Lemieux. I'm a partner there, been practicing since I began in 2018. Corey, let him talk about his background, and then obviously Mark is here with us as well.
Sure. Corey Lloyd, I'm also at Reese Lemieux with Robert. I'm of counsel. Prior to my time at Reese Lemieux, before I was a lawyer, I was a commercial construction project manager for Woodward Design Build and other companies. So about 20 years of experience in the construction industry and about 8 years experience in construction law.
Hi, I'm Mark Baum. Thank you for coming, and look forward to this session. I've got about 40 plus years experience, too many years, and mostly I'm a sole, similar to you all, a small firm. I'm a sole practitioner, and do my own projects, but also do some consulting with a number of firms in the areas of project management, construction administration, do some quality control review. I see some of the people I've worked with over the years from Traplin Peer, Wisnia, Practice is not here. I don't see anybody from Practice. Studio Curo, made a list here, so I don't forget anybody. Nano, worked with, and Concordia, Rome Office, and Perez. So thank you for coming, and look forward to a good session.
Yeah, and so we were, like Emily said, we're presenting some questions. So we're going to kind of walk through some of those ones we know of, and then to the extent anything arises or you have a question as we talk about a topic, feel free again to bring it to our attention, and we can try and address it. One of the kind of overall themes, I think, was the AIA document template itself, starting with the B101, and some of the items that are actually omitted or not modified in the B101 that you had some questions about. So we're going to kind of walk through a few of those. We've prepared a kind of sample excerpt and modification handout for everyone. It should be in front of you. That has some additional items in red that we see in practice that are inserted into the B101 for the protection of the architect. So we're going to kind of walk through one of the first ones, which is the indemnification clause, which is going to be on the last page of your handout. We've received questions on how this works in practice, what options are available to y'all as the architect to modify to insert a protection for y'all. So I think Corey's going to kind of talk about what the indemnification provision standard B101 is, and then some ways and some suggestions we have for y'all when negotiating with an owner to modify it.
Yeah, and I'll start with posing a question to you all is, what does the room think indemnification is, or what does it mean to you when you see that word in a contract? No wrong answers. Protect. That's close. That's good. Yeah, the one thing that always, it was a hard word for me, that these two words don't really sound alike, but they kind of do. Indemnification has the M and the N, money. Indemnification is money, is who's paying after the loss. So when there's an indemnification clause in there, in the contract, it is discussing why the owner may pay you if they cause a loss, or why you may pay the owner if you cause a loss. It goes with defend and hold harmless. Defend could mean that you defend the owner if you cause a loss to the owner. And hold harmless would mean if you cause a loss, you're not going to go blame the owner for it. So indemnification is at the end of the line. It's who's paying the money for the loss that's caused. The B101 is silent on indemnification. There is nothing that's included in the form AIA document. Robert and I were talking, and a little with Mark as well. That might be what we prefer for designers. Is there, you carry a PL, professional liability policy. As one of my former colleagues says, you don't need to break yourself into jail trying to write the perfect indemnification clause. It's perfectly acceptable as designers to have your contract be silent in terms of indemnification. Conversely, if you have an owner that's insisting on all the other owner contracts, their contract with a general contractor or other suppliers, whatever it is, they are used to seeing indemnification clauses. And they might insist or try to insist on an indemnification clause getting inserted. So the sample version on page 5 that's in red ink is a mutual indemnification clause, which it's 2 paragraphs. They basically read the inverse of the other. The first one says, if you, the architect, caused the loss, you'll hold the owner harmless and indemnify them. Second paragraph is the other way around. If the owner causes you harm, they'll defend and indemnify you. And this is enforceable from a general sense. It's, there's a whole lot of anti-indemnification law that we would get into with contractors that doesn't typically apply to you all as designers. But I think, it sets the ground rules. This clause can set the ground rules of if you cause a loss, what happens on the, contractually, what did you and the owner agree to? And conversely, if the owner causes you a loss, did they agree to indemnify you in writing? And I know you had more thoughts.
And I think, as we talk about some of these provisions, we're going to talk about the AIA template, but also there's a conversation about, maybe a form for your company. And so I kind of am curious on the majority of the projects, quick show of hands, is an owner trying to make you indemnify them? Are you getting a one-way indemnification provision in the contract being presented to you for the most part? Or so typically silent for y'all. Yeah, and so that's why, again, going back to the B101 standard is a lot of people will just see, okay, it's in the B101. Let's just go with that. So, to the extent you're not getting it from the owner, that's helpful. And then to the extent you do, make sure it's mutual. Make sure that you're being indemnified for their acts and their persons they have on the job site, their personnel, things that they may cause damage to you or your employees and your work. And so one of the other, again, to get more granular with it in terms of protection, we'll talk about the standard of care, obviously, for architects, and what we want to limit. The next section will be the limitation of liability. Y'all's liability on a project to your professional services and performance of the agreement, right? And so one of the other modifications here, if you are being stuck with either potentially a one-way indemnification, the owner won't agree to indemnify you, is you push forward to the extent of not just my negligent acts or omissions, but my professional negligent acts or omissions in performance of the agreement. That's just a smaller carve out that really provides for the money, the defense and indemnification. It's not going to protect you necessarily from third-party claims against you and their liability, your liability to them, but in terms of your requirement to defend and indemnify and pay for the owner's loss, it could protect you.
Mm-hmm. Yeah, correct me if I'm wrong. I mean, the indemnification, you already have your professional liability, and owners have a tendency, and even attorneys who aren't experienced in practicing construction law have a tendency to want to put the same liability and the same responsibilities on the architect as they do the contractor. who has the largest stake in and the largest investment in the construction. The architect doesn't really have that same liability, but owners don't. And some, like I said, some attorneys that don't deal with construction law on a day-to-day basis want to have the same language in your contract. Right. Yeah, your fees, the contractor is making approximately a similar amount, maybe 6 to 10% profit on a project, where your fees are the 6 to 10%, and you got to pay everything out of that. You're not making anything close to what a contractor makes, so you shouldn't be held, in my opinion, to the same standard of liability that a contractor has who's actually performing work on site.
Spoken like a true architect.
Well, that's what we're here for.
When I've never been in a position to have to use it, you have an example, a typical example of where this could be challenged, you put it in real life. Oh, okay, I kind of understand the representation. If I have to talk to like one of my, maybe it's not a developer client, it's the client who's dealing with this type of work for the first job. What does that really mean? Usually if you give them a real, real case scenario, everyone kind of understands where that could potentially.
Sure. So a couple examples where are you asking where you're looking for indemnification? Okay. Okay. Often, and hopefully always, but often it's going to be when there's an insured loss. And that's one of the things that attorneys like Robert and I will try to keep the indemnification bound to, is that if there is a claim against you or your firm, that you at least have insurance for it, and that you're not indemnifying for something that applies outside of insurance. A couple examples, I'll bounce around a little bit, but from the professional liability standpoint and a design standpoint, it could be, pick on maybe, if there's no structural engineers in here, don't want to make something collapse, but there's a member that was undersized. It was noticed during construction. It cost more than just the replacement to pull one steel beam out and put a new steel beam in. You had to do a little demolition and, put it back in efficiently. The indemnification there would be, the contractor's deserving of a change order in that scenario to remove one beam and replace another. The owner owes the money to the contractor. The structural engineer indemnifies the owner in that scenario and pays the difference, or pays the cost to replace the improperly sized beam. So that's a professional liability example. Another example where you might indemnify them for what we wrote here is, you somehow cause a personal injury on the job site. You come and you pulling up to the job site and you hit the gas and not the brake. You cause a personal injury, you cause damage to someone's piece of equipment. You would be indemnifying and holding the owner harmless for your negligent action. And again, hopefully in that scenario, you would have general liability and or automobile insurance that would pick up the cost of that loss. And again, and we'll get to a couple other topics here later, you don't want to indemnify the owner for not getting the permit timely. You don't want to indemnify the owner for, promising I don't even know, a certain revenue based on your grand design. You just want to indemnify them for the actions for which you should be insured. Sure.
You feel indemnification better or is silent better? I would say it's silent. Again,
For you all.
yeah,
Yes.
for y'all. I think it's less likely that there'll be a claim by you against the owner than there would be a third-party claim against the owner for something you did. Um, so I think that's why silent is probably preferred, and we just wanted to highlight,
We got questions about indemnification there were multiple questions about indemnification, so we wanted to address if an owner is forcing it into your agreement, this is is a way that's usually acceptable to agree to.
yeah.
Would you repeat again why silent?
So this is a contractual obligation to indemnify the owner for your negligent acts. If it is silent, there is more ambiguity on if you're responsible to make a payment to the owner. And it ultimately is something that the owner will use and point to and say, you did this, you caused this, you have indemnification to me for this negligent act or omission. Whether it is a professional negligent act or omission, or if it's silent on professionalism, if it's, again, a car accident at the job site, or, you caused, I mean, we're people, right? Accidents happen. Y'all are going to these sites and things can happen due to your, again, negligence is not some kind of intentional act. I threw something at someone. It's, I accidentally forgot to close the window, at the job site, and the whole thing got, rain blown in, or, some kind of,
Kicked the 2x4 off the roof and it fell on someone's head.
correct. So the third party, we cannot, you're not going to be able to contract liability away from that person that you injured. You're still going to be responsible to that person. But this is really for more of, are you also going to be responsible for picking up the defense and the payment of money of that defense or that issue to the owner? Does that make sense?
A lot of case, our insurance company asked the architect to do why.
Yeah. So the question was, sometimes some of you all's insurance company asks to add indemnification language. The reason for that would be they should be making sure that the language only covers actions for which they're insuring you. They're trying to keep you in those bounds, and better for them. Their perspective is better to write in what they know than to leave it blank.
And I mean, with the idea that maybe starting with it silent and that leaves more ambiguity, I don't know, to me, ambiguity is not a good thing because it doesn't, you still have a problem that needs to be resolved, and it just kind of carries the issue further on than it needs to, when you might have to go to, mediation or arbitration.
Yeah, let me address that. General question is, isn't ambiguity bad? I'm not disagreeing with you. Ambiguity when you're defending yourself can be better. And I think that's a good transition into next topic, which is, let's go on the offensive for you architects right now and talk about limitation of liability clauses and something you can add to your contracts and why that's something you should consider.
Yeah. I didn't mention, I do serve on the AIA documents committee, and that's one thing that's always a big conversation is when and where and what type of contract should have limitation of liability. I think most architects want to have some limitation of liability in every contract, but the AIA does not have that in their agreement because it tends to be controversial, and because as I mentioned before, people kind of think of architectural services sometimes in the same vein as they do construction services. And they're saying, if an architect gets a limitation of liability, why shouldn't the contractor get a limitation of liability? Well, I mean, it is really apples to oranges. And So AI has been very careful about putting LOL language in its template agreements. At least that's one of the reasons. Um, you're almost never going to get limitation of liability on public projects. That's maybe on quasi-public projects if you're working for, say, a charter school directly or something like that. But if you're working for a public entity, it's rare, if almost non-existent from what I've seen. And the limitation of liability can be anywhere from whatever dollar amount you set to the amount of your fees to the amount of some portion of your reduction in what you carry in insurance. It can be almost anything. So, I mean, I would recommend it, and I think it's usually pretty common to be able to get a limitation of liability with a private client. And it's just a matter of explaining to them that what their risks are and how the risks are covered by the insurance, by the contractor, and what you are contributing and where their risks lie with the architect.
Yeah, and I think just like the indemnification provision, the B101 may be silent because this is a legally divisive concept across all 50 states. It's not going to apply the same in each state. In Louisiana, you are contractually allowed, keyword written contractually allowed, to limit your liability in advance of a project, in advance of an agreement. To, like Mark said, option one could be the amount of the available and paid out insurance proceeds. That's that first option. Another option could be the amount you actually received in payment under that agreement. And you're never going to be able to limit your liability for your grossly intentional or fraudulent acts, right? That's just going to be something that there's a specific code article that says you cannot in advance limit that liability because we don't want people to be able to do that. So some of the options here, these options 1 and 2, are meant to cap your exposure on one specific project. You have projects that probably are anywhere from $1,500 to millions of dollars, right? And so you don't want that potential $2,000 project to turn into a $100,000 headache, right? And so your risk in getting into some of those smaller projects could be it's a smaller project, a part of a much bigger project, right? And so this is something that kind of allows you as a business owner to determine, okay, this is something I'm willing to do, a smaller issue, because I know what my exposure could be. It's limited to my insurance, or it's limited to the amount I may actually receive. While this is allowed and enforceable in Louisiana, facts and circumstances may change depending on what the loss actually is. Ultimately, it would be for a judge or jury to decide, whether the loss outweighs that advance limitation of liability if it arises to some kind of grossly negligent or significant breach of the standard of care. So again, these provisions are architect offensive, things that we want y'all to include in your contracts to protect y'all that may be negotiated down by the owner or the owner's counsel to something more of a middle ground.
I want to add, the AIA is not going to put language in a contract that's not going to be legal in all states. It's a template that's used universally, so they don't want to have language in there that's not going to be acceptable in a particular state, and that's one of the reasons why it doesn't appear in some cases. When I'm negotiating a contract, obviously I want to limit my liability to 0, but anything above that is, I'm going to try to get there. And probably the worst cases I want to be is the remaining limits, the remaining available funds on my insurance. I don't want the contractor to go after my, the owner to go after my house or my car or my computer or whatever is left in my office. So the available limits are whatever is available after legal fees, after any other judgments, if you have any. And that's a risk to the owner because they don't know how much is going to be available at the end of the day. But that's really the kind of the worst case you want to be at. Sometimes you don't get that at all, but if you're going to limit it, you want to try to limit it to what your insurance is going to pay.
Yeah, and I think another concept in terms of potentially limiting your liability, or at least getting a meeting of the minds, Corey and I kind of talked about, what a contract should look like for y'all, not necessarily from a legal perspective, but getting the owner to understand what your role is on the project and what your role ultimately will be and what their role is. And so the next option is this limited contract administration services, where if the owner elects not to retain you to actually perform the CA, perform the responses to the RFIs during the project, that you're telling the owner, I'm not providing you a full design because I'm not here till the end, till substantial completion. I've given you the construction documents, but I'm not there to interpret them. I'm not there to answer the questions the contractor may have. So again, this is a provision that assists in the event there is a claim that may not be because your design documents were in error, but they were interpreted incorrectly during the project. So Mark, I don't know if, on some of these they're not residential, but the smaller projects, if you're not staying on for CA, if you kind of have that conversation.
I started my private practice 30 years ago, and I have never taken a project that I don't do CA. So I can't really speak to that because I won't take it. I mean, to me, it's too much risk. And 30 years ago, I took on projects that I wouldn't take on today because you're trying to make any buck you can. But I would not take on something that I did not provide full services for. It's just, if you're divorced from the project after you turn over the construction documents, you're not at the table to respond to issues and protect your own liability.
What do you think of that? Another option clause that for whatever reason, let's not use you for CNA.
Well, if you can get it.
The issue there is legally, even with that type of provision, if there is an error or something that wasn't correct in your construction documents, you'll still potentially be in a breach of that standard of care and responsible for whatever flows from there. There may be some defenses that, it would have been caught in construction if I was there, or if a simple RFI was issued to me that I could have explained that. But again, that kind of gets into the reason we exist and the reason that on different projects it may be more favorable, or they're more likely that the fact that you weren't there caused the issue, or the fact that if you would have been there, the issue would have been caught.
Right.
Yeah.
Sometimes in smaller projects where you might be working hourly, and the owner might not want to use, not want to call on you, or they want to limit the number of staff because you're working hourly. I've put a couple different things like minimum numbers of site visits or a clause in my contract that states that the architect will use to perform contract administration services as a and so that the owner can't come back and say, just come for an hour, or, and I didn't know if there was, we had language that we would use for hourly. It's very simple and fixed.
Yeah, well, my first thought is that's great to write that in. If you, kind of similar to what Mark was saying, if you need to perform or need to provide certain services to sign the contract as a whole or perform the design, absolutely should insist on that and let that be a deal breaker towards not designing the project. I was thinking as you were saying that on page 3 of our handout, section 4.2.3 has standard terms for, this is straight from the B101. It's the maximum amount of services that you will perform as part of your stipulated fee. We could flip this around and say that the hourly services shall include at least 1 monthly visit or 3 visits over the course of the project, or whatever you would need to feel comfortable signing up. And I think the way to, I'm just thinking about how we would negotiate that with the owner is inform the owner what portion of the fee, we could set up an hourly contract with an anticipated fee and tell the owner that $3,000 of the fee or whatever it is going towards these mandatory monthly, for example, site visits, and assure the owner that way of, yes, you're going to go to the site as needed, but this is how much it's going to cost.
Yeah. Minimum for a number of site visits that you recommend, like once a month, once a week?
I think that's really project specific, dependent.
It is project specific. I mean, I would think to me as a minimum, you'd be there at least on a monthly basis, but that's really, in my opinion, very minimal. I'm typically on my job sites at least once a week, in some cases once every 2 weeks, depending on the size and scope and involvement, what the project is, how intensive how intense the construction is and what's going on. On residential, I don't do much residential. It's probably a little bit different ballgame as to how many times you're going to be on site. So that's, those that do custom residential probably have a little bit different protocol as to how that works.
Common amount that you typically would see or recommend, like you had mentioned, people to your architectural fee, or like 5 times the fee, or a certain dollar amount based on the construction cost?
Yeah, I think what Mark was talking about earlier is, we prefer you to limit it to the available insurance proceeds first. And to the extent they want to bring some kind of provision the first 0. And then to the extent, it really is just going to be, I wouldn't say there's a one size fits all for that provision. It really is looking at the project. Okay, I'm getting a $10,000 fee. This is a $2 million construction project, or whatever the case may be. There's a lot of different moving parts and parties out here. I would want to limit it to, to your point, $50,000. That's the worst day I'm going to have out here. If you don't limit it to the available insurance.
Yeah. I think you have to balance it with the size of the project. If you're doing $1 million project, and let's say your fee is 8%, $80,000, and you have $1 million or $2 million coverage in your professional liability, well, you don't want to give every client your entire policy.
Yeah.
You want to try to limit it to what is reasonable. I mean, and this is hopefully a conversation you can have with your client. If you can't have these conversations with the client, maybe it's not the right client to have. But limit it to something that is reasonable. What's the worst case you could do? I mean, as far as the architect goes, you're not building the building, you're designing the building. You could screw up and there could be a failure. Well, your insurance is going to cover that, but you need to be able, if you're just doing interior renovations and there's no inherent risk of structural failure because of what you're doing, well, then maybe your liability should be a lot lower than that.
Louisiana, did you say that the limitation liability should be cited? That's still there?
No, from y'all's perspective, a limitation of liability is important. It's something I would want to include in each contract.
Regarding the contract administration, I agree with Bob, we look at the but if we took project in the past, it's better to put
running through the drawings to see that we have actually. And the state by much alone for that.
You know, or, yeah, like notify the permitting office that.
I mean, I think that's not gonna hurt you. I think what's the most important is what you have in your contracts between the owner and you that specifically lays out what you are and are not doing. Because that will be the first place anyone looks in the event there is a loss. So if you're going to not perform the CA, you need to have, or I would recommend you have a provision similar to what we have. It says, I'm not going to be there for that, and I'm disclaiming liability to the extent allowed. That will be your first line of defense if there is a claim. Say, well, I wasn't there, owner, and you knew I wasn't going to be there.
Yeah, I mean, one of the weapons you have is that you, on a commercial project, you have to sign off to the fire marshal that the certificate of completion. And you have to tell the owner, look, I cannot sign that certificate unless I have reasonable access to the project on a periodic basis, and certainly a final inspection of the project to be able to put my signature on that form. Well, 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 hopefully you had that conversation before construction with your owner that you're not doing it, and that's going to be an issue at the end of the project. At that point, I would tell them, no, I can't do it. And I already told them no several months previous. That's their problem at that point. Right, but you haven't been on the job site watching the job and observing the work, so how can you sign agreement? Well, I'm saying, if you haven't been there observing the work as it's being done and you didn't do an inspection at the end, how can you sign something that says the work has been performed in accordance with the contract documents and the law? Sure. Well, absolutely, yeah, absolutely.
Yeah.
But unless you've been there and done it, I mean, I think you're taking a tremendous risk doing any kind of certification as to what happened when you weren't there.
Or the, that's the site obligations, right, required by, in order to fulfill that obligation, that's not actually today, as far as contract. That would be site obligation, not signing up for that.
Sure, I think,
Working outside of that contract, if I didn't have full CA services that did go into the site.
yeah, I think in either case, if your initial contract just has design, anything else that you do post the start of construction, whether it's true CA with pay apps and site visits and deficiencies and punch lists, or it's I'm just here to sign a certificate of completion for the state fire marshal. Either way, that's an additional service, and compensation should be due to you before you agree to go, and to the extent you can, at that point in the project, observe the fire alarm and the fire sprinkler and firewalls and paths of egress and everything else. So I think maybe the bigger lesson here is don't get yourself in that box.
Right. That's
being clear with the owner up front.
right. I mean, have the conversation during contract negotiation or when it starts construction that, these things are going to be required at some point, and you're going to have to figure out how to do it if you're not having me on the job. It's just,
Yeah, fortunately for you, the owner can't issue a CCD to you and say, come sign the certificate of completion, right? So
right.
if you get it clear up front, you can't be persuaded to do something you don't want to do at the end, at least without compensation, fair compensation.
But also, you should really check your insurance policy because sometimes it's kind of written into there that you're expected.
Mhm.
Even if you like read
Right,
insurance, it's telling you
yeah.
that's basically, if someone tells an accident, thing, insurance won't let us.
And that's a,
And it's a good way to move on from it because, again, those clients, owners that are trying to do that might have to be very sophisticated and they don't want to deal with insurance stuff. If you tell them that it's kind of, yeah, you're right. But you gotta be careful.
You, yeah,
and that's a great point. Your insurance agent is a resource and a tool. They won't know the latest case law and limits of liability they'll have some association with, but they'll be able to tell you this isn't covered by your insurance. And so that's when you get something questionable, in addition to counsel, an insurance agent can also help.
we move on.
Yeah. Next item that someone asked about were consequential damages. And start by addressing what are consequential damages. And those you probably hear more often liquidated damages, which is more applicable to contractors, where if the contractor doesn't finish the job in, say, 365 calendar days, they're exposed to $1,000 a day in liquidated damages. And I don't think it is. Yeah.
This is a standard B101 term that's not
Yeah,
in the handout.
Yeah,
If you're looking for it, it's not.
Yeah, sorry, but it was a question that was asked. So that was a liquidated damages. If you do this, this is how much it costs, regardless of, we pre-negotiated it in advance. Outside of that, that's a time-related delay applicable to a contractor. A consequential damage can be applicable to a designer or a contractor, and it can also apply to time or not, but it can be, examples are a loss of income, loss of revenue or rent, or carrying costs on a loan while the project is in design and or construction. And you do not want to sign yourself up for these, of course. And the A201 has a very explicit waiver of consequential damages, which most public entities strike through. And many private owners try to negotiate with their contractors. I think the B101, if you sign up, what you need to take away from today is two things. One is if the words consequential damages appear in a contract, you need a mutual waiver. You cannot expose yourself and should not expose yourself to signing up for consequential damages. It makes the indemnity discussion look minor in comparison. The amount of revenue an owner can lose if for any reason they can come after you for consequential damages. And then the second takeaway for today is any time obligations that you commit to an owner, how fast you'll issue design development drawings or permit drawings or whatever it might be. You can include words in your contract like endeavor or attempt or anticipate. But if you cross a line where time is an essential element of the contract or time is of the essence, you are then telling the owner, you're not only paying me to design this project, you're paying me to perform this task by this date certain. And if you don't, you are exposed to damages. So that's kind of how consequential damages can work. The ultimate takeaway is never get exposed to them. Any questions on that? Yep.
I mean, just about time in general, takeaway, right? We shouldn't have anything in our contract about when we're gonna be submitting for permit or whatever, just because of the way that can happen.
Yeah, that can be hard to avoid. The question was, there shouldn't be anything in the contract about time. And some of the contracts do have in the programming section, anticipated timelines. And some owners, it's going to be hard to get away from that with them. But I think being clear up front, these are goals is, just in conversation is important. And the risks that go with that, if something gets kicked back, right or wrong, from the permit office or the state fire marshal or whoever it may be, that's not under your control. And then, so that's just the conversation, the upfront understanding, and then in the contract, time cannot be of the essence, and in full stop.
Yeah, there's a difference between language saying, you will endeavor and make good faith efforts to start the permitting process upon execution of the contract, right? But there's a difference between that and you will make your best efforts to obtain a permit by December 1st, 2025. And that's what we're trying to make sure when you're reviewing these contracts from your perspective, that you're not agreeing to a hard deadline. And if you are agreeing to something like that, make sure the consequential damages that may expose you to lost profit, rent, carrying costs, all those things are included, because you'll be responsible for everything that flows from your failure to meet that timeline and the next time.
Yeah, are included as waived.
Yeah.
That's what.
Yeah.
Kind of the flip side of that, like if you plan out, let's say 3 or 4 months to do the drawings, but then the owner drags it out for over a year. And meanwhile, it's hard to make it hard to schedule projects.
Right.
Start. And then over that time period, all of your costs of running the business have gone up. How do you address that when an owner drags something out?
And there are provisions in the termination sections and that it can address those issues as to if the owner hasn't provided responses in certain timeframes and all that. If it gets to that point, fine. It's kind of a hazard of the job. I mean, to some extent, you kind of have to flow with it if you want the job. If it gets really abusive and problematic, there are there are provisions in the termination section, termination for cause, what have you, for putting, having a little bit of a hammer over that issue and explaining to the client, look, we cannot continue to the project because if we cannot move it forward, or you suspend the project for a period of time and then have agreed on cost to restart the project. But what we're referring to is Section 2.2, the architect shall perform its services as expeditiously as is consistent with such professional skill and care and the orderly progress of the project. That's what the contract, the standard AIA contract says. It does not provide a specific schedule, but also just be aware in 3.13, it also says the architect will submit a schedule for the owner's approval. Again, that's what they're saying. Don't say it will be done unless you're forced to by a certain date, that you will endeavor to do it. You will, these are goals. They're not necessarily set in stone as drop dead dates where you may incur liability.
I've been trying to figure out how to work this or when I'm trying to put the project on hold. And then starting the project up again, that they are sort of at the back of the school. Right? And that they don't even know it's water, which would be
I want to just finish up on the owner responsibility and then address the suspension article that we can talk about. But Corey and I, there is an article relating to owner responsibilities under the standard B101. We like to put in, y'all are given all these timelines and deadlines to respond to RFIs, typically, right, within 21 days or whatever the case may be. I know Mark says it costs doing the job, but we like to